How private is anonymous? How many of you fill out anonymous surveys or send in anonymous emails? It's kind of funny because about, maybe it was a year ago, 2 years ago, we received at the Privacy Technical Assistance Center a anonymous email from somebody that was accusing us of being terrorists and that they were going to kill us and our children and things like that. So our security guy, who's not here, just kind of did a little random trace, and in about 10 minutes he got back to me and said, well, this guy lives in Buffalo, he's a retired police officer, here's the company that he owns, here's a picture of his house, here's his license plate number. This was all within 10 minutes. So what you may think is private in the technical world is not necessarily, and that's really what we're going to talk about today. So, a long, long time ago, we used to get our files moved from place to place. When I moved from school to school, I had a cum file, right? That's what we used to call them in the old days. Well, now we have information stored everywhere on the cloud, in foreign countries. When you're storing information on the cloud, many of you don't know where that information is being stored. It could be in India, it could be in Mexico, anywhere that there are server farms. So this is exactly where we are today. People know that, and people are concerned about where their children's data is going specifically. 52% of organizations expect to fall victim to a cyber attack in the next 12 months. 52%. I would tell you that probably 25% more are being very optimistic. The number of breaches are occurring on a more daily basis. A long time ago, we also didn't have hackers. Did you know that there are over 400,000 registered hackers in China alone? Just in China. Registered. You can register. There are good hackers and bad hackers, right? No, there are. Okay, so the guy that I was talking about, he actually is one of the good hackers. He works for the Privacy Technical Assistance Center, but he also does some work for some of those secret agencies such as NSA and others, and they bring him on to actually see if he can penetrate their systems. Hacking has become a commodity, though, going back to the registered hackers. You can go on YouTube and learn how to hack. You can get tools for free that can actually go and penetrate websites and other information. We now see that you can go onto websites and you can buy identities for, I think it's $4 a pop for children's identities, other social security numbers. It's all available online. So here are just some of the biggest hacks of 2014. Obviously, JP Morgan Chase, 83 million households and small businesses. That affected 65% of all US households. Home Depot had the 56 million credit and debit cards. Sony, movie was held hostage, right? They couldn't give it out for fear of some sort of terrorist activity. Anthem Blue Cross, thank you very much. I got my letter in the mail. I keep getting more and more letters. I still don't know what the impact is, right? How many of you have had your identity stolen? And how difficult was it to find out about exactly how you were impacted, whether people were doing it, using your credit? It's a very frustrating process, and you really don't know until something bad happens, right? eBay had 145 million, and this was only email addresses and login credentials, but people could purchase stuff on your behalf. And I was one of the 145 million there too. Target, 110 million credit card numbers. So this is just the best of 2014, or the worst, I guess you'd say. Since 2005, more than 75 data breaches of 1 million or more have been reported. It's been estimated that only 10 to 15% of data breaches are actually reported or known about. So it may not be that they're not reporting it, they don't know. Recently, we found a large education institution that it appeared that their website was being owned, we call it pwned, but owned by an outside entity. They didn't know they were continuing to conduct business on that website, but we established that that someone was essentially scraping the information. So you heard about those credit card scrapers where people put them in gas machines and ATM machines where it takes some information off of your debit or credit card or ATM card? Same type of thing. It looked and acted like their regular website, yet the hackers were getting all of that personal information as people were entering it into this large university's website. It's estimated that 43% of companies had a data breach in 2014. All this is to say that, again, there are very real concerns by these privacy advocates out there. A lot of times they may seem a little bit ridiculous, but when you think of it in that context and you watch the news and the fear around this, parents have good reason for being concerned. A long, long time ago, there also weren't laws on privacy. There weren't laws on data breach notification, vendor responsibilities, and all of these legislative bills that specifically focus on privacy and privacy of education records more specifically. Now, nearly every state has a data breach notification laws, with some civil, and there are even some states, like Louisiana, that have criminal penalties if there are education data breaches. Imagine being a school district person like you all here and being responsible or being held responsible criminally for a data breach in one of your systems. And believe me, when one state starts one of those legislative laws, they kind of cascade to the rest of the states. Nearly 40 states have education data bills strengthening the bar set by Ferpa. So remember, Ferpa is a federal law. It's the lowest common denominator of what you have to do as far as protecting student records. States can certainly make those laws stricter, and many have. There are also some civil penalties in some of these laws for collecting data that isn't in state or federal statute. Okay, so they're getting very serious about the amount of data collected. Why is that though? When you think about exactly why this is going on, there's not a whole lot of output of this data. A lot of data is being collected, but not a lot necessarily being given back to the parents or community. We're getting there, but we still have a ways to go. The same kind of thing, we recently got a request from another state asking, under Ferpa, do we have to give parents this information at the state level? We're working with a contractor, they're asking the contractor for the data. We'd like to say that we can't give it to them. Why, was my question to them. What are you trying to hide? Because at the end of the day, that's just going to bring on the media and the questions and the suspicions by folks. So there's been a lot going on the national level as it relates to privacy, right? The White House has put out a privacy bill of rights. Congress is currently looking at revamping Ferpa. We'll see if they actually get something done with it, but at the end of the day, there could be some major changes to Ferpa as it relates to how you can share education records. The vendor community now has really gotten engaged and going, we really got to get ahead of this. We are being put in a spot, we don't understand our relation to our responsibilities around educational data. So the Future of Privacy Forum and the Software Information Industry Association announced a pledge to safeguard student privacy built around a dozen community commitments around collection, maintenance, and use of that personal information. How many of you have heard of the Student Privacy Pledge? Not many of you. So the vendor industry is starting to get on board with this because they realize that they have responsibilities around this. Now you remember last year we talked about, and some folks asked questions about Google and their use of student information, mining email and things like that. Since then we've discovered that there are other companies that are doing the exact same thing. most vendors really want to do the right thing. Many of the vendors you have here really want to protect that data and want to be good stewards of it. It's those few that put a black mark on all of us. Same with the sharing of information with parents. It's those few examples that make national news, that end up on a national news network, that really make things difficult for us in the education community to be able to use data like this conference is promoting. So what's in the pledge? Well, the pledge makes clear that service providers are accountable to not sell student information, not behaviorally target advertising. Now you know that Coppa, many of you are familiar with that, actually protects student information from marketing. And the FTC, unlike Ferpa, actually has some teeth to what they do. They do fine companies for doing that. If they find out that they're marketing to children, they actively go out and fine those companies. You can't use data for, you can only use the data for authorized purposes only, not change privacy policies without notice and choice. This one's really interesting. So how many of you have iPhones or Androids? Pretty much everybody, right? And there's maybe 2 people that have a Windows phone in here. Don't raise your hand. So for the rest of us, when you download an app, how many of you just click accept? Don't actually read through it? I mean, don't lie, I do it too. You don't actually read through those. Well, in some of those, there are actually clauses that state, we may change these and you accept any future changes to this privacy policy without notice. Why would any of us agree to that? Think about that. You're agreeing to they could essentially stick anything in there going forward. A lot of these click wrap agreements have that kind of information in them. They reserve the right to change the terms of the policy without notice. So this pledge is saying that these companies who sign up to this pledge are not going to do that. They're going to enforce strict limits on data retention, so they're not going to keep the data forever. They're going to support parental access to and correction of errors in their children's information. Vendors don't necessarily have a responsibility in that, but in this case, they're saying we'll also allow that access. Now, of course, in many cases, they're going to need to work very closely with the school districts and make sure that the right person is getting that information. They shouldn't just give it to someone who says they're the parent. Providing comprehensive security standards, so they're actually starting to develop the kinds of security standards that need to be in place, and then be transparent about collection and use of the data. So those are the main keys that going forward that they're looking for. So recently, Congress has been having hearings with a focus on expanding the legal definition of an educational record. I know I can't tell you how many questions we've received at the Family Policy Compliance Office of the Department of Education around when an email record becomes part of a student record. And the answer is always it depends, because a lot of times it does depend. Now they're looking at including digital data and metadata generated by software, websites, applications, and online learning platforms as being part of education records. What does that mean? That means that information that's being used in the classroom for apps and things like that would be subject to Ferpa protections. They're also looking at expanding Ferpa to apply to vendors and not just educational entities. Right now, penalties are only to people receiving or agencies that receive education funds. They don't extend to the vendor community. Going forward, they're looking at possibly expanding that to include that vendors have a responsibility around Ferpa. There have been times and some things in the media where we've seen vendors actually have the breach, yet the school or district is ultimately responsible for that breach, right, at the end of the day. And a lot of the state legislative bills hold the public entities responsible. They're also looking at including graduated enforceable series of penalties for Ferpa violators, allowing individual families a private right of action. So that could be a major change. Again, families could then take action if Ferpa was found to be violated. And then including requirements around data security standards and notification of data breaches. Right now, unlike HIPAA, Ferpa doesn't have security standards. It has what they call reasonable methods, and if you come to my Ferpa 101, we'll talk a little bit more about what that means. But essentially, it leaves the ball in your courts to decide what's considered reasonable. All right, now we're going to watch a short video. This one is one we just released, and it's focused on using online services, online applications. It kind of explains it. The actual document's 14, 15 pages, so for those of you who don't like to read 14 or 15 pages of guidance, we created a 9-minute video. So with that, if we'd start that video.
Computers and the internet have changed the way we live and learn. We work, shop, communicate, share pictures and video, research information, and play games online. Many schools and districts have embraced the new technologies and are using them to improve education services and instruction. Today we're going to talk about your responsibility as teachers and administrators for student privacy when using online educational resources. Because the fact is, no matter where student records reside, they should still be protected. Let's take a look at the ways teachers, administrators, and staff can practice good data management when using online educational apps and services. Then, we'll talk about how you can protect the privacy and security of student data when using these types of services in your schools and districts. Before using educational apps or services, it is important to learn about the variety of federal, state, and local laws impose requirements and restrictions on how student data can be used, and the conditions under which it can be shared with application developers or online service providers. Let's examine some key privacy laws that may apply. The first is the Family Educational Rights and Privacy Act, or FERPA. FERPA is a federal law which protects the privacy of student education records. Most public schools and districts are required by law to comply with FERPA. Simply put, FERPA restricts how PII, that's personally identifiable information, from education records may be released without the parent's consent. FERPA may allow schools to disclose certain information, like students' name, date of birth, or photos, without consent as directory information. This is often done in school yearbooks and athletic programs. A school may provide directory information without consent to third parties, such as service providers, only if they publicly notify parents about its directory information policy. This notice has a number of requirements, like it must state what personal information is considered directory information, and that parents have a right to opt out. But be careful, because parents can opt out at a later time, so using directory information with online services can be tricky. Another FERPA provision that permits PII from education records to be disclosed to third parties without consent is the school official exception. Schools often use this exception to outsource IT and other institutional functions. It is sometimes advantageous to outsource school functions to save money or to get better services. If your school outsources under FERPA's school official exception, you must make sure that the third party is providing a service or function that the school would otherwise provide itself, and you must be sure to retain direct control over the use and maintenance of the information you disclose. Sorry, FERPA isn't the only federal law in question. Let's briefly review a few others that might apply. Another law is the Children's Online Privacy Protection Act, or Coppa. It applies to websites, apps, and online services that collect information from children who are under the age of 13. Coppa requires verifiable parental consent prior to collecting personal information from children online. In some cases, like when a student must use a website or an app for school and there is no commercial purpose, Coppa allows schools to exercise consent on behalf of parents. In addition to FERPA and Coppa, other federal laws may apply, like the Protection of Pupil Rights Amendment, or PPRA, and the Individuals with Disabilities Education Act, or IDEA. While we are not discussing them here, these other laws may impose additional requirements on your use of online apps or services. As you might expect, not all laws apply in all circumstances. To spare yourself a headache, spend a little time researching which requirements apply to your particular situation before signing up for a new service. Oh, and don't forget about the laws in your own state. They may apply as well. You may wonder, does FERPA allow schools to share PII from education records with online service providers? Yes, FERPA does allow you to share PII from educational records with online providers in some instances. With prior written parental consent, it's always acceptable to share PII from education records through the Directory Information exception and under the School Official exception. But remember, officials can only use PII from education records to perform the specific service or function that you directed them to provide. We just reviewed how FERPA protects students' education records, but the truth is that FERPA may not apply to all of the data collected by online service providers. That is why you must pay close attention to written agreements, contracts, and terms of service. If your school or school district wants to use third-party online educational services, it is important to get your ducks in a row and create a proper written agreement. Even if it's not required, it is always best to create one. A written agreement sets expectations for necessary security controls, as well as specifying data collection, use, redisclosure, and retention and destruction procedures. Your contract should specify how long the agreements will last and how they can be modified or terminated. When drafting a written agreement, remember all applicable legal requirements. This process may be difficult, but a little pain now can save a lot of pain later. So far, we covered what you should do when contracting for online services in a conventional manner through a written agreement. Increasingly, however, online services and applications use a licensing model known as click-through or click-wrap, where you can sign up by simply clicking a button or a checkbox to accept the terms of service. This can lead to potential problems. Meet Ms. Jones, a high school teacher. She just found a great new app to help kids with math through games. Her students love to play games, and the app is free. More and more teachers like Ms. Jones are making use of apps and online services. Many providers offer innovative and helpful content, often for free. But be wary that sometimes the saying, "nothing is free," might apply. Some apps require the acceptance of terms of service. These can be long, boring, and full of complicated legal language. Ms. Jones needs to fully understand what she is agreeing to in the terms of service. We may not think of clicking an accept button as the same thing as signing a written contract, but they can be legally binding agreements. For these reasons and more, Ms. Jones should talk to the appropriate individuals about the school's policies and procedures before signing up for the app. Administrators should review the app and the terms of service to make sure it won't adversely affect student privacy or the security of the school's systems. If your school or school district doesn't already have a process for reviewing and approving apps and online services for classroom use, you should create one. Here are a few suggestions for reviewing apps or services that use a click-wrap agreement. Identify who within your school or district will be responsible for approving the use of apps and services. Create an easy way for faculty to receive feedback about third-party apps or services they would like to use in the classroom. Use this process to screen out those that may pose security or privacy risks. Read through terms of service carefully. They may be long and full of legalese, so talk to your administrative or legal team to help make sense of them. Print and save a copy of the terms of service for your records. Online providers sometimes include provisions in the terms which enable them to change the terms at will. Check often to ensure that the terms have not been changed unacceptably. Technology in classrooms can improve education by expanding our knowledge, communication, and productivity. But as we enjoy these new tools, we must be mindful of the risks they bring and follow best practices to secure and protect students' private information. We have discussed how to protect privacy when using online educational services, but there is a lot more to know. Talk to your school or school district administrators about local policies and procedures for using online services. Also, check out the U.S. Department of Education's Privacy Technical Assistance Center website at ptac.ed.gov for more information on protecting student privacy while using online educational services.
All right, so how many of you are familiar with your policies and enforce those policies with teachers in the classroom on downloading applications and having students enter information in them, or having students use those apps. I don't see a lot of hands raised. If you take nothing else from this presentation, one of the things you should do is look at your policies and start to think about what is being used in the classroom. You may be giving away students' privacy without parents' permission by using those applications. How many of you have virus software on your handheld devices? Not very many. The #1 distribution of viruses right now are on your iPads and on these handheld devices. In fact, you're probably giving away your privacy right now if you don't have virus software. I loaded it on shortly after I found out that, and found that 2 apps were actually sharing information from my contacts and things like that. They were very popular applications. These weren't fly-by-night applications. So be really careful. I'm going to go back one slide. The other thing that we actually are going to release April 6th is model terms of service. This is where we talk about what kinds of things should be in your terms of service. I'm going to go over some of that today because I already have the document, obviously. I've seen it. But a lot of districts have said, that's great, don't just tell us this, tell us what we should be looking for in our terms of service. So we put together a guidance document that talks about that. All right, so as that video showed, student information systems, productivity applications, educational applications, and then fundamental school services. These are all online education apps. They're usually what you contract out to do. This guidance related to this subset of education services that are computer software, mobile applications, or web-based tools. They're provided by a third party to a school district and accessed via the internet by students and used as part of a school activity. So again, it's important to remember that that information is still protected if it's got student information. So it may be that directory information, your directory information policy says that, but as I've gone to school districts around the country, a lot of folks have not looked at their directory information policy in years and they're not up to date. So they're using more vendors, they're using other types of outsourced or nonprofit organizations that they work with. You should review your directory information policy and make sure it represents who has access to those education records. The school official exception, that's part of your annual notification, okay? Or some people call it the Ferpa notice at the district level. In that school official exception, or the annual notification, you have to specify who you consider at the district level to have access to education records, who you consider to have legitimate educational interest. This includes vendors. You don't have to list every vendor, but you should say types of vendors. We contract out with student information service providers, with transportation service providers, things like that where we may share information. Now, a lot of parents think that they can opt out of that information. The only information parents can opt out of is the directory information policy. Okay, so that's the stuff maybe you share with Jostens or others, yearbooks and programs that you do for athletic programs. The school official exception, you just have to notify parents that these are the types of people that you give access to, and that includes vendors, and they can't opt out of it. You just need to let them know. So directory information, again, this policy was changed in 2011 where you can have limited directory information policies. So a lot of districts thought that you had to, if you gave it to one person, you had to give it to everybody. So we made changes to the regulations to allow districts the latitude to say, here's what we consider directory information, and we're only going to share this information with our yearbook provider, our parent handbook, things like that. Otherwise, what was happening is many school districts were frustrated or didn't put together a directory information policy for fear of a marketer coming to the school district and saying, well, that's directory information, you have to give it to me. Or it could be a child predator. You have to give me, pictures of the kids, and it's directory information. Under this new policy, you can limit it to specific individuals or specific groups rather than just giving it to anybody else. And that can also limit who gets it for FOIA or whatever your public records laws are here in Pennsylvania. So if you don't want that to be part of that, you can narrow the scope of it, and it wouldn't be subject to that. It would be protected by Ferpa then. So again, directory information, this is the area that parents have the right to opt out of, not the school official exception. A couple of criteria for the school official exception that I want to go over, and this directly relates to working with vendors. When you work with vendors, it has to be a function which you would otherwise use your own employees. If you had just unlimited resources and you could hire 30 IT programmers and create your own student information system that didn't have bugs and didn't have upgrades every year, right? You'd do it. But the fact is you have to contract that out. The second bullet, a lot of vendors get concerned about, but it's only direct control as it relates to the use of your education records. It was 18 months ago, New York had a big issue with a outside vendor possibly using information for other purposes. The state needed to enforce direct control as it related to those education records, but it became a public nightmare and kind of got out of control. But at the end of the day, your vendors can't reuse student information even for marketing purposes, right? That's still the district's control of the data. That should be in your contracts and MOUs with them. The last two, focusing on redisclosure and using it for unauthorized purposes, very important. All right, so when you're working with these online services, is that information protected by Ferpa? Well, we talked about this. It's our favorite. It depends. Some data is protected by Ferpa, others may not be. You really need to have a process in place, and if you take nothing else away from this, again, go back and review your policies as it relates to working with applications. There are a lot of those that are giving away information. They're collecting information and giving it away on your behalf. Under Ferpa, are providers limited in what they can do with student information that they collect or receive? Well, it depends. So again, if it's under the directory information policy, if someone gets it under that, you have a general directory information policy, there's no redisclosure. So if someone takes that yearbook information, they can give it to 30 other providers if they want to. That's not subject to Ferpa's redisclosure. Under the school official exception, they can only use it for the purpose in your contract with them. They can't sell that personally identifiable information. And again, there are some limitations as it relates to the PPRA for those students as they're collecting maybe survey information and things like that. Metadata, are there restrictions on what people can do with metadata? Again, this is information such as they're maybe tracking click-through and how long it takes them to come to a certain answer. Again, if this has been stripped of all direct and indirect identifiers, it's fine to use that for them to use that information. The problem is, are you as the district going to go through and verify whether that data is actually correctly de-identified? And then of course you have Coppa. And this applies to, and I know districts are really good about the side of these, but I think part of that is because there's an enforcement mechanism behind it, right? When you're working with vendors, they know that they could be fined if they violate this. So again, this tends to have a little more teeth to it than Ferpa does. So if we want to get through this, to summarize, if we want to start to change the perception of education data, these are the things we really think that are important. Obviously know what other relevant laws here in Pennsylvania apply. Be aware of your online educational services and how they're being used. You might be surprised if you took an inventory of your classrooms and found out how many applications are being used and what they're being used for. You need policies and procedures to evaluate and approve those, certainly you don't want to keep teachers from being able to do what they need to do, right? You want to give them that opportunity to be creative, but there still needs to be a process and make sure that those applications truly are free. When possible, use a written contract or legal agreement. Be transparent with parents and students. My district's a great example in Frederick. They are very transparent with us with what they do with the data, how they use it, and I get a lot of data back, so I'm pretty comfortable with the policies that they have there. The district I was at in Oregon, not so much. They were always collecting information, but I never received anything back, and it made me very uncomfortable, so I opted out of everything I could. And remember, sometimes, so we had a teacher recently send us an email and ask, I want to use this application. It does collect some personal identifiable information. It collects weight. We're actually doing a nutrition type of program. What's the best way to do this? And we said, well, the best way would be to get parental consent. It seems like something that could be a good program, but you really should just go through the process of asking parents to consent to participating in that particular online nutrition program where they would enter in calories and how their weight was doing and how much exercise they did and things like that. Again, you probably should have policies that don't have individual teachers just signing up for freemium education services. You should have a process in place to make sure that it truly is free. Again, if you're doing this under the school official exception, you have to directly control those third parties as it relates to that, and I doubt the contract terms of service allow you to control them as it relates to student data. The other thing is a lot of these services can introduce security vulnerabilities into your school networks. So by allowing these applications on, you might actually be creating a security hole and allowing hackers a way into your student information systems. So what's in this new guidance? So the new guidance that's going to come out on April 6th represents provisions that may be found in a terms of service privacy policy or other contract offered by a provider of online educational services. So these are guidance documents to help guide the conversation. For years, the department's been kind of silent as it's related to electronic records. We're releasing guidance documents about every quarter as it relates to this. Click-write agreements. Many providers rely on a terms of service agreement that is not negotiated. And again, you've probably, just like me, scrolled past many similar agreements and said, I agree, when adding an app to your phone or tablet. Remember that some of these could lead to a violation of Ferpa or PPRA. So be very careful about that. Be very wary of just the click-through agreements. You probably should actually read those and make sure that they're not collecting information and sharing it. So this terms of service will help you evaluate these terms of service. So you'll be able to actually look at the things that we think should be in those terms of service. Again, much of the legalese found in these are very confusing. By understanding the commonly used provisions, school or district officials will be better prepared to decide whether consenting to an agreement would be in the best interest of student privacy, right? Every school district should have a designated representative who reviews the agreements before they're used in the classroom. So that's what we're saying in the guidance document, that you as a school district should have a representative who reviews these agreements. It should be inventoried, evaluated, and support the school or district's broader missions and goals. And this will help you tie it to the school official or other appropriate exception.